Hello class, I am Yoel, and my group consists of Regina, Gabriella, and Ifoma, and we will be presenting an analysis of the Wisconsin versus Yoder case. Wisconsin versus Yoder was a breakthrough case in regards to religion and how much a state can interfere with religion. Here are the facts of the case. 3 Amish students of separate families stopped attending the New Glarus High School at the end of 8th grade due to their parents' religious beliefs. The state found them guilty of violating the law, and they were called into a trial. Jonas Yoder, a father, represented the 3 families in court. They were found guilty, and each defendant was fined $5. Seeing that this is a violation of their First Amendment right, they took up the case with Wisconsin Supreme Court, which found in Yoder's favor. Sustained respondents claimed that application of the compulsory school attendance law to them violated their rights under the Free Exercise Clause of the First Amendment, made applicable to the states by the 14th Amendment. The state of Wisconsin, unsatisfied with this ruling, appealed the judgment of the U.S. Supreme Court. What was Yoder's argument? Well, they claimed that in the Amish church, higher education is not necessary to live their life, which was factual, considering that they had a much simpler life compared to the average American. Another claim is that their children would learn more at home compared to the public or private schools, prioritizing vocation since it is the basis of their livelihood. One of their greater arguments was that higher education endangered their salvation. So, what is the constitutional question at play? Did the state law of making children attend school until the end of high school, and then punishing those who didn't comply with said law, violate the parents' First Amendment right? Well, the decision was that yes, the state did in fact violate their First Amendment right in regards to the Free Exercise Clause. The court ruled unanimously in favor to Yoder, 7-0. Despite this unanimous decision, there were both concurring and dissenting factors at play. Dissension. William O. Douglas believed the children's interest was not being taken into account and that the case was only based on the parents' right. On this important and vital matter of education, I think that children should be entitled to be heard. He may want to be a pianist or an astronaut or an oceanographer. To do so, he will have to break from the Amish tradition. Concurrence. Justices Potter Stewart and William J. Brennan Jr. filed a concurring statement against Douglas's dissent, stating that the questions raised are invalid because the children shared the same opinion as their parents. As the court points out, there is no suggestion whatever in the record that the religious beliefs of the children here concerned differ in any way from those of their parents, said Stewart. Justices Byron White, Brennan, and Stewart stated that the case would have been different if the parents had forbid the children from attending school. They also mentioned that despite the fact that the children will miss 2 years of secondary education, it would not hinder them from participating in modern society. This would be a very different case for me if respondents' claim were that their religion forbade their children from attending any school, since the Amish children are permitted to acquire the basic tools of literacy to survive in modern society by attending grades 1 through 8, and since the deviation from the state's compulsory education law is relatively slight, said White. Why does this case matter, and what is its significance in history? This decision was a breakthrough in American history because it applied an old piece of writing to a modern situation, and more specifically, it found a way to draw a distinct line between state and religion when it comes to the issue of education.